Hi, my name is Andrew Kinney. I'm an attorney at DisabilityLawyer.com. I practice in the area of Social Security disability law, and that includes SSI law. I've been doing this work about 20 years. This video is explaining to you about what medical experts are, what they do, how they're used. Medical experts, traditionally, people associate them with Social Security hearings. They can be at Social Security hearings, but you need to keep in mind that Social Security contracts out work in making medical decisions at the first two stages to state agencies. So if you apply and then to get denied and appeal your Social Security claim, you're going to have two decisions made by doctors that are hired by Social Security through the state contract, and you will never meet them. They're going to make decisions about you. Those are medical experts that you don't see, but they're very important because you need to influence them, and they don't accept phone calls. One thing your attorney can do at the first two steps with these medical experts is make sure that your treating physician has weighed in with an opinion in your records. We can explain to our clients some details about that. The medical experts that people most associate with Social Security claims are at the Social Security hearings themselves. You perhaps waited maybe 1.5 to 2 or more years to get to a hearing. You're meeting with a federal judge. You're in a hearing room, and in that hearing room, there's generally always a vocational expert, but in this case, there can also be a medical expert. Generally, in my experience, the medical experts that are brought in on an annual basis, and they're generally the same people, and they have background in either psychology or physical medicine. And the people that have one or the other doctors, generally it's because it's the worst medical problem in the file that the judge brings them in. The goal of a medical expert as an independent doctor who is paid by the government, the goal of the medical expert is during the hearing when asked to give an opinion about what's wrong based on the medical records, and also give an opinion about how you're limited. So if you think about it, in the Social Security hearing itself, you'll have your attorney next to you and you'll be speaking. The attorney will ask you questions after that, and then the judge may get advice, if there's a medical expert, from that medical expert who does not know you about how you're limited. So really, in the end, some cases can turn on the opinion of the medical expert. That is what your attorney is supposed to do after the opinion of the medical expert comes out at a hearing. Your attorney is supposed to ask reasonable and very specific questions, hopefully anchored on the medical record itself, about what the medical expert testified to, what's the basis for it, what's the conflicting opinions in the record, why follow one opinion of a doctor and not another, and why even outright ignore one from your treating doctor, which is what I commented on earlier. Your attorney is supposed to make sure that the hearing is fair and that the advice the judge gets is balanced. In the end, the judge makes the medical decision as to whether you're disabled or not. But if you have a medical expert at a Social Security hearing, make sure you have your artillery, your attorney, to ask that medical expert the questions that fairly relate to the truth of how bad you really are. If you have more questions about medical experts or Social Security in general, please feel free to go to DisabilityLawyer.com as you have. If you have any questions, we'll be happy to help you. Thank you.